All right, Ralph Pettis. Thank you. All right. Court is calling 2022 CR 11882, State of Texas versus Ralph Pettis. Can I have parties announced for the record for the state?
Thanks to the state of Texas.
Defense?
Luis Martinez on behalf of Mr. Pettis.
All right, and are you Ralph Pettis?
Yes, ma'am.
Your attorney has filed a motion for continuance. State, have you had a chance to review?
Yes, Your Honor.
Do you have any objections to the defense's motion for continuance?
The state has no objection.
All right, and defense, what is the purpose for your motion for continuance?
Judge, my investigator's out of town until the end of this week. I can't present the case without him. He's spoken to witnesses. He may be an impeachment witness. And so I'm asking the court to reset it till after the end of this week.
All right, Ms. Ferguson, are we able to recall this? You say in 2 weeks?
The 17th, the 30th, I know those dates are available. Those
All
are
right.
just fine.
Ms. Ferguson, when do we have impact? All right, this defense's motion for continuance will be granted without objection. And you will be coming back on October 30th for impact court.
Yes,
All right, and Ms. Ferguson will give you a reset form.
Yes, ma'am. Thank you.
You're welcome.
See you next time.
Mr. Aveles. Court is calling 2022 CR 4683, State of Texas versus Juan Pablo Aveles. Could I have parties announced for the record for the state?
Brittany Mitchell for the state.
Defense?
Luis Martinez on behalf of Mr. Aveles.
All right, Mr. Aveles, is
Yes.
that you?
Yes, ma'am.
Your attorney has filed a motion for continuance. State, did you review the motion for continuance?
I'm aware of its existence and I'm aware of the reasoning, Your Honor.
Do you have any objection?
Your Honor, on this particular case, it is, unfortunately, it has a number of settings and including it was re-indicted at one point. And our witness is out of county, so we're ready. So I would object on this.
Defense?
And Judge, and this is not for delay, but as I've stated previously on the other case, my investigator's out till the end of the week. I did not know that until the middle of last week. When I found out, I immediately informed the state before I filed the motion for continuance. He'll be back at the end of this week. Anytime after the end of this week, I'm available and ready, Judge.
So you're saying that your investigator will be available the week of October 9th?
I need to get subpoenas reserved. So the week of October 17th would be good. I know, like I said, if you've sent me the impact on the other case, I'm fine with that too. Whatever the court can do, I appreciate it, and I apologize for the delay.
I mean, in the event that we're accommodating him, I would ask for, a quick date, Your Honor, about October 30th.
All right. All right, the motion for continuance will be granted. And this will be scheduled for October 30th in impact court.
Yes, ma'am. Thank you.
You're welcome.
Truly sedate me.
And Your Honor, I have prepared a motion for continuance on Philip Diller.
All right, I'll hear that when I call it that case.
Okay,
Okay.
I was gonna run and get it notarized.
Oh, yes, you may go. All right, Norma, that will be October 30th impact. Lauren Carrillo.
I think Brittany is also handling that one.
All right,
Well, here,
state,
I can check with Brittany and see.
she was objecting to, she had filed a motion for continuance. All right. I don't know, are you prepared to proceed on that motion or?
I think, let me just see.
All right, well, we'll wait for her.
You can proceed.
Oh, we can proceed. All right, if you all can come forward on Lauren Carrillo. Court is calling 2023 CR 5313, State of Texas versus Lauren Carrillo. Could I have parties announced for the record for the state?
Travis Banks of the state of Texas.
Defense.
Jamer Rich, Your Honor, for Miss Carrillo.
All right. The court is in receipt of a motion for continuance from the state. Defense, you previously stated that you have objections. Is that correct?
That's Your Honor, and yes, that's correct. The copy I got wasn't notarized. Is the fourth copy notarized?
Yes, it is. All right. State.
The state's witness is unavailable for trial today, and the state's asking for a motion for continuance for another setting when this witness would be available.
All right. Has the witness been subpoenaed?
We've been unable, we talked to the witness a while back over the phone, and recently we've been unable to reach the witness by phone, so we haven't even been able to talk to her by phone or.
All right. Defense.
My understanding, the last time they talked to her was in May. I know that we've tried to make contact too. She's moved and been evicted from number of properties, phone numbers the family had for her has been disconnected also. She's kind of gone into never land. I just was, if they're going to set it, we've got to say that they tried due diligence at least in trying to contact her, other than saying the phone's disconnected. No subpoenas issued. No other information on her, and we object to the motion to continue.
All right. Motion for continuance is denied.
Judge.
All right. So you're all up for trial
Okay.
on this case. Next up will be Zachary Sanchez. Mr. DeLeon,
Judge President, Your Honor.
can I see the file on Zachary Sanchez? If you'll just give me all of the files. Thank you. All right, State, are you ready to proceed?
State's ready, Your Honor.
Defense is ready, Your Honor. I need to talk to Ms. Mitchell one more time, but otherwise,
All right. So you'll be number one number two. We'll see what happens on Miss Carrillo.
we'll be here, Your Honor.
All right, Dakari Jackson. And are you all ready for trial?
Yes, Judge, we're ready. We're still conferring, but we are ready.
All right, you're number three.
Thank you, Judge.
Todd Dodson. You are number four. Christina Sorio is number five and Diller is number six. Can you mute us, please? Thank you. So, guys, what's happening with Zachary Sanchez? I believe we are. All right, so we're gonna bring the jury in. 60 seconds. Yes. We will hold Opera on the king because that's supposed to be complete.
If we approach,
Yes.
Judge, we are at an I'm sorry, my client can hear. We're at an impasse, Judge, but I'm specially set in the 437th on Tuesday on a continuous sexual abuse of a child case. I'm getting ready for it. It is 25 to life, obviously, and I'd like to have a brief continuance.
You're already, I'm not, I mean, it is, I think the first time it's come up for trial, so
It is.
I know we have other older cases.
So
But
here's my question. So he's saying he's specially set for trial next week.
No doubt.
So is this trial gonna finish this week?
it should, Your Honor.
What's today?
Tuesday. Got a week.
Still.
Let me think on that.
Okay.
Zachary Jackson.
Your Honor, I didn't see Alfonso this morning, so I haven't had a chance to confer with him yet
All right,
this
you all are
afternoon.
Yes, Judge.
Y'all have 10 minutes.
Yes, Your Honor.
Oh, yes. I know. Good trying.
So they're gonna be jury selection. They're ready to go. Something from it unless everything works out, which appears that's not gonna happen. Oh, because everybody wants to try. So with regards to plea negotiations, it's really up to the person who's accused whether or not they want to accept it or not. So they have that choice. Courts, hopefully their attorneys and attorneys that over the evidence that the state have. And they've seen that. They know whether or not that you're actually going to trial. So when I look at my clients, I always make sure that we sit down. Sit down. I was reading through this report, I would have my investigators go out and talk. I would talk to every witness that was on the state's list, and I would also talk to witnesses that they don't have on their list. Because sometimes you discover different things from talking to witnesses that they would say.
Yeah, yeah.
You know, so I would always do that, and then I applied for the information on whether or not they wanted to go to trial, whether or not they wanted to create something. Because otherwise, there's no go to your client and say, this is what you're charged with, this is what they are, what you want to do. They're really not making an informed decision, since you want to say, okay, what evidence do they have? Who are these witnesses? Do I know any of these witnesses? Are these witnesses coming in? Have any of them been subpoenaed? Those are things that you want to define. So clients get a chance to decide if they want to go to trial or not. Of course, if the state says we're not offering any plea bargains for next day, to go on the trial.
Yeah.
And then they get to decide if they want to go to the jury for 100% of their file guilty or still sort of the questions. With regards to bench trials, a lot of people don't realize that a defendant is saying, I want the judge, in my case, I don't want a jury for it, but the state is entitled to a jury trial. So the state can say, no, we don't agree to that, the jury is here. But it just really depends. It's a thing, then they get.
So,
I would like that, guilty or not guilty or no contest. Sometimes judges will say, I'm not accepting your contest. But no contest, she's on the criminal side, the reason how is because maybe there is silver suit that is rising. And sometimes you have someone.
okay, we did ask.
All right, so the next drive out, she's changing things. I want to accept the plea.
And she said there's
But
not
I'm
actually.
gonna get sued on the civil side for it. So if they plead guilty, then you can just take that guilty plea over there, and then the only issue will be how much money you owe. But if you no contest, they still would have to go over there and prove that one you cost, and then how much cost. So it's a lot that goes into it. Oh, it is. And then you have to know all of the collateral consequences when somebody pleads. Ethically, as an attorney, you don't have to tell them every potential collateral consequence, but I always would. For my young clients, I always tell them, this is how this is going to affect your ability to get loans for college. This is how it's going to affect your Pell Grant. This is how it's going to affect your ability to become a voter. I would do all of that because I think that's a part of knowing intelligently. Should I plead? Should I not? Right. All right. I told them till 2, so it's not quite 2. We'll knock on the door and see what's happening. Yes. Oh, they were supposed to come back and talk to me. I know it's the one where he is.
Okay, so we're not gonna open up anything right now. Okay,
No, because
I just wanted
they're
to-
supposed to bring me more information.
okay. I just wanted to make sure about the CPS, right? About the child.
Yes.
Okay.
So once they
He
get
did,
back,
he did report here. He is here and they're working on just that, that's just in case.
Okay.
And do you know anything that happened on this last Thursday? It's just on this docket sheet. She was supposed to come back, she's in her she's pregnant. She's gonna see about Casamia.
yeah, I never got the information that she made it to us.
She has not,
All right,
but she was supposed to be here this past Thursday.
and she didn't show.
She did, she's
it will
in
be-
custody.
All right, let's have her brought over. See if they can have her brought over. Thursday, Friday. Friday, come on.
Yeah, I just.
You know what, I tell you what, if you have her brought over tomorrow, I'll send an email and we'll see what's happening with Casamia.
They never got back to me. Or so they.
I'm gonna call the person that I know over there.
So, she said, I'm.
So they are going to, they're talking to Alfonso Tabanos right now. And we're gonna see what's happening with this case. And then the next person up then is gonna be Todd Dotson. Okay. How long are you expecting this trial to last, Mr. Dotson?
Probably 2 days.
Okay.
Zach wants
Oh, sure.
first.
I say, let's do it. Oh, well, they're working on Mr. Zachary Jackson. Then after that, Todd Dotson is going to be up.
I think we're gonna work out.
All right, and then Zachary Sanchez, is that going to be worked out? All right, and then you have the continuous sexual assault.
Yes.
All right. Okay. Then if you all are not. And you say that's how many days you think that will be?
Why 437 case?
No, this case.
It's a solid 3.
All right. And then, so that's not going to be able to go state since he's going to be in the continuous. And we have 3 or 4 days.
Especially if you go to punishment.
All right, Norma, on Zachary Sanchez. What date? All right, December 4th. And that's in the 144th, correct, counsel?
No, 430.
437. Ah.
This morning. And then confirmed it.
All right, so we'll bring you back on December 4th.
Thanks, Judge.
Everyone, Zachary will be coming back on December 4th.
I'll make a note of that.
All right, thank you. All right. And then Dakari, you all say that's working out?
Yes, Judge, we have an agreement, Judge.
All right, if you all will do the paperwork. So then up next is Dodson.
We're ready. Born ready, good. Ready, Judge? Is that one? We're gonna start with that one?
Yes, they're gonna do the
Right.
paperwork on this and then we will take Mr. Cabanos.
Yes, Judge.
We're gonna do the paperwork on you all. We'll take up the plea at a break.
Yes, Your Honor.
Okay.
So.
Yes. Yes. And then if you'll give us a moment with you, we're gonna see if this actually goes. Sometimes
All right,
people
Judge,
say that, but then it doesn't.
The state has filed a motion for continuance. One of their
No, we have
witnesses
the leg
had
brace.
pretty serious surgery.
Mhm.
And they're saying she can't travel for 8 to 12 weeks. And it's this weekend,
Because he has leg iron.
So are you gonna have any objection?
for the record, yes, but
Then we need to hear that.
okay, all right.
Yeah.
that's fine.
So we're gonna take up this jury and we'll take that up at a break.
Okey-doke.
All right, thank you.
Thank you.
You're welcome.
I think she's.
I'm not.
Oh, well, we're gonna sit there.
Yes.
No rule that required for you to say.
Well, it needs to be closer to the door, so yes.
Okay.
All right, on this case, are you all proceeding on all three counts?
Your Honor, the state's gonna be waiving the third count, that's proceeding on first.
All right, we'll go on the record. Yes.
Thank you.
All right, you're welcome. All right, if your client were to be found guilty, is he coming to the court for punishment or the jury? All right, has that paperwork been filled out?
Not yet, Your Honor.
The chairs go on the other side.
Just a second.
No, you're fine.
Vashawn, I'm emailing you the information on Casamia.
Okay, thank you so much.
That's what, for the free on the Carrie Dotson, logistically, are you wanting to do it?
Oh, we're gonna do it after they, each side is gonna
Just
get
make sure
30
if
minutes.
it's gonna be another.
So it'll be
computer,
very
it's gonna
quick.
be On this, yes,
All right, and can you
Yes, sir.
make sure that the paperwork is done on
it has a
King Alvarado
PC,
as
it
well?
has a PC little picture on here and it'll go straight over there, but we'll test it out right now.
Yeah, absolutely. Let me find that PDF on my cord.
It's otherwise than one little issue.
All right, and the issue that she had an objection to, that's stuff.
Yeah.
Okay.
I mean, in a way, it's still gonna kind of be up to
Okay,
You and I are learning together on that one.
Very, very.
Oh, yeah, mine. No, no, not at all.
There you go.
Time out of your day.
I'm sorry, I misunderstood.
No.
Yes.
It's somebody else.
yeah.
Is it this cable, Travis?
Yeah.
Where would you like us to wait, Josh?
I think it's one of those and if that
Um,
doesn't work. we will probably-
Wherever you guys want to wait. You can wait in the
All right.
hallway. We're gonna bring the jury in.
Oh,
Just to simplify it. we can put it down.
all right, we'll be out in the hallway.
All right.
And, let's see what it passes.
I did, I pulled up HDMI. I'm using restroom.
We got it.
Okay, sure.
The HDMI only.
Yeah, I switched
You go
it
to the
to
bar.
HDMI. Okay.
And. HALLIE. He's PEASE.
She's on this.
I have a second chair.
Oh, okay.
Thank you.
Do you mind if I move this little movable car over here?
Oh, sure. I do, well, I said Shay, no, I have no problem if you want to do that.
Yeah. Make sure.
All right, each side will have 30 minutes. What's the time announcement? Does anybody want a time announcement?
5 minutes.
Okay. 5 minutes? Okay. And is Mr. Dotson eligible?
No.
Okay. All right, court is going to call 2023 CR 2674, State of Texas versus Todd Jael Dotson. Can I have parties announced for the record for the state?
Zach Dunn for the state, Your Honor.
Defense?
Mr. Dotson.
And are you Mr. Dotson? All right, are both parties ready to proceed to trial? State?
Yes, Your Honor.
Defense?
We are.
All right,
Judge just needs to be sitting second with me from the Mac house.
okay,
And Your Honor, Travis Banks will be sitting second.
all right. Have both parties, I'm sorry, defense, have you received the discovery acknowledgement? Has that been signed?
We have not received that.
All right, have you received all the discovery in this case?
We have, Judge.
And did you review that with your client?
I did, Judge.
All right, the court will find that the state is in compliance with discovery. I'll need an acknowledgement of discovery signed today. Does everyone understand?
Yes, Judge.
Mr. Dotson, did you have a chance to review the indictment with your attorney? Did you understand it? All right. State, are you proceeding on the indictment as presented?
Your Honor, the state's going to be waiving the third count.
Any
Proceed.
objection?
No objection.
All right, and what else?
No, Your Honor, that was everything.
Okay, sorry for interrupting.
No, ma'am.
All right, so it's the court's understanding that count one then is an assault family second and count two is an assault family second. Is that correct?
That's correct.
That's correct.
All right, let's bring the jurors in.
First row?
First row.
Yeah, first row, because the end has numbers in the bench. Okay, on the chair. No, ma'am, you actually have a chair assigned to you. They're all behind. Because you have a second. And I First row. Can you guys pass through there? Yes, okay. 15, who's 15? On the bench. This way. 22?
Next row, next row. 30. 30, next. All the chairs have a number. Yes. I'm making sure.
All right, everyone, please be seated. All right, everyone, good afternoon. Wait a minute, this is what? Okay, everybody's on delayed response. Good afternoon, everyone. All right, I know you all have enjoyed standing in the hallway, but I want to let you know, none of that is due to either of the parties that are here. So I am Judge Boyd. This is the 187 District Court, and you are on the 4th floor of the courthouse. So where are you? Hey, you guys are trailing off like you're singing Old Lang Syne, where people know the first verse and then they just trail off. So I'm Judge Boyd. This is the 187 District Court. You're on the 4th floor. So what floor are you on? What's the court number? Who's the judge? I know you're probably asking yourself, why is she asking us this? We absolutely 100% know where we are. The reason why I always ask that of jurors is because sometimes we'll take a break. And when we take a break, sometimes people want to take a restroom break. Sometimes people want to go downstairs, and then people get lost. We've had people who have been on the jury panel and we're waiting for a juror and waiting for a juror. And then we discover them down the hallway trying to be selected on another jury panel. So that's why I always ask that question. So if ever you are on a break and you look up and you see everybody's gone, you'll know where you need to go. There's only one 187 District Court in this courthouse. So if you ever get lost, if you tell somebody you're looking for the 187th, they'll be able to tell you. If you don't remember the number and you just remember Judge Boyd, I'm the only Judge Boyd in the entire courthouse. All right. So if you remember those things, you will never be lost. This case is the state of Texas versus Mr. Dotson. So if I could have members of the state, if you introduce yourselves to the jury, please.
Hello, everyone. My name is Zach Dunn.
Morning, or good afternoon. My name is Travis Banks.
And for the defense?
Hi, I'm Elizabeth Russell.
I'm Haley Pease.
And Mr. Dodson, if you'll introduce yourself.
Todd Dodson.
Thank you. All right, so in your possession, you have something that's very valuable. They are cards with numbers on them. So could everyone please raise your card? Do not lower those expensive cards until I tell you to lower the expensive cards. So those numbers signify your number on the sheets that we've been given. So whenever somebody asks something and you want to respond, you need to hold up that card. And if they want to call on you, they will call on you by your number. Now, don't lower your card. 13 is getting excited. Don't lower it yet. So when I tell you to lower your card, I want you to lower your card for me. Everyone in the box, lower your card. Everyone on this front row, 15 through 21, lower your card. All of the people, if you still have your card up, which you should, those are people, whenever you're answering a question, if you can, I'm going to need you to stand. And the reason why I will need you to stand is so the court reporter can hear you, because believe it or not, the acoustics in the courtroom are horrible. All right. So if your card is still raised, whenever you're answering a question, please stand. And what I can tell you is, so far, and we're in trial almost every week in the 187th District Court, so far, no jury has been able to follow that instruction. But I have complete faith in this panel. I said that about the other panels too, but I really feel something about this panel. So I think you guys will be able to do it. So you can lower your card. To my left is the court reporter. I always said, if ever it was in my power to make somebody's job easy, I would try to do that to the best of my ability. So let's make her job easy. The court reporter takes down everything that everybody is saying. And believe it or not, if she has her record and she's not taking down everything that somebody's saying, even if it's not her fault, people upstairs, when they view her record, they'll say, what's up with this court reporter? She can't take down a record. So she has a license the way all of us have a license. And that's a license saying that she's qualified to do her job. It will be extremely difficult for her if we all talk at once. So to make it easy for her, we're all going to speak at this tone, and we're all going to speak one at a time. And I know it's difficult sometimes because we're used to having conversations where we finish somebody's question, or we think we know where the question is going to lead. But to help her out, we're not going to do that. When a question is asked, we're going to raise our card, and the state and the defense will not talk over anyone as well. Does everyone understand? Yes. Can everyone do that? Yes. Right. So I'm going to talk to you a little bit about certain rights, and then the state and the defense will have a chance to speak with you. Now, in this case, the charge is assault family second offense. And I'm going to come back around and talk to you about that. But what I want you to know, when I speak to you, when the state speaks to you, and when the defense speaks to you, they're going to be speaking in hypotheticals. None of them are allowed to talk to you about what they think the facts are in this case. The only way you'll hear about what they think the facts are in this case is if you're on the jury panel. Does everyone understand? Yes. So when they speak to you, don't be thinking, oh, well, this is what happened in this case. They're not allowed to do that. Now, in order for a case to come to a felony court for jury trial, there has to be an indictment. We're going to practice with the expensive cards now. How many people here have had a traffic ticket? Raise your card. All right. So I see why there's so many horrible drivers in San Antonio now. I can say that because I've had a traffic ticket before. You can lower your card. So I've only had one traffic ticket. And when I got that traffic ticket, I was probably maybe 18. I'm 21 now. So, okay, that shouldn't, okay, I heard a real high laugh. Number two, come on. But when I got that traffic ticket, it was during the time frame where they used paper. So the officer would write out the ticket, give you a copy of the ticket. Now I think they're doing electronic things. So let's say you have a traffic ticket and they say that you ran a stop sign, and the officer pulls you over and you say, hey, why am I being pulled over? And they're saying you ran a stop sign. So they give you a ticket. When you accept that ticket, you're not saying, yeah, you're right, I ran a stop sign. That ticket is just telling you, I'm saying you ran a stop sign. This is the municipal court where you need to go to answer for this ticket. If you want a jury trial, we'll give you a jury trial. So an indictment is similar to that. An indictment is just letting you know what you're being accused of and where you need to go for trial. It is not evidence of guilt. It cannot be used as evidence of anything. Does everyone understand? Yeah. It's just the means whereby somebody is brought to a felony court. Now, Everyone has a right to remain silent. Where are my Barnaby Jones, Matlock people? Jessica Fletcher. Don't be shy. Raise your card. You know who you are. But thank you, 47. Number 2, paper chase. What? The practice? Marcus Welby, MD? Trapper John? All right. Thank you, number 15. So anyway, everyone has a right to remain silent. That means that you don't have to testify if you choose not to testify. I've been a defense attorney. I've been a prosecutor. Sometimes when I was a defense attorney, I would tell my clients, you don't need to testify. The state didn't prove their case. So there's no need for you to testify. Or sometimes my clients would be super shy because if you can imagine sitting in a box where everybody's staring at you and you're asking questions, you're thinking, oh my gosh, did I turn left? Maybe they think if I turn my head left, I'm not telling the truth. So sometimes people are just extremely nervous. Sometimes people have different stuttering issues or something like that, and they just don't feel comfortable and they're extremely terrified. The thing about the right to remain silent is that everyone is afforded that right. And so what that means is if Mr. Dotson decides not to testify, you cannot hold it against him. You cannot consider it as any type of evidence. Does everyone understand? Yes. Is there anyone here who cannot do that? Is there anyone here who will hold it against him if he chooses not to testify? And I just want to tell you, the person who's sitting to my left, I'm her mentor. So she is a former student of mine at UTSA. So sometimes we'll have people who will come into the courtroom and they're trying to make a decision whether they want to be attorneys or whether they want to be in the legal field. But I just want to let you know, she is not involved in the case and does not have any information about the case. And sometimes you will see other people who are sitting on the side here. It's the same thing. You may see people coming through that door. It's because they didn't read the sign on the door that says, do not come in, we're in a jury trial. The people who come through this door are usually staff or officers who have something for me to sign. But what I want you to know is the persons who are coming through this door with documents for me to sign has absolutely nothing to do with this case. Now, I want to talk to you about burden of proof. Everybody who is charged with a criminal offense is presumed to be innocent. So what does that mean? That means because they're presumed to be innocent, they don't have to prove anything. The defense does not have to put on any evidence whatsoever because everyone's presumed to be innocent. The state has the burden of proof. If you're ever on a jury and you say to yourself, well, I wonder why the defense didn't present A, B, or C, or I wonder why the defense didn't do this, then you know that you have given them the burden and they have zero burden. When I was in law school, they would always tell us, you have no burden. You can go to sleep. You can play crossword puzzles. And the reason why is because you don't have to prove anything. I have yet to see anyone go to sleep and play crossword puzzles. I don't anticipate that happening during this trial either, but it's just to express to you the seriousness of it and that the defense does not have to prove anything. Does everyone understand? Yes. Now, burden of proof, what is that? The state has to prove their case beyond a reasonable doubt. And I know some of you all have heard that phrase before, hopefully. If not, then you'll probably have to watch Barnaby Jones. But proof beyond a reasonable doubt, what does that mean? When I was in law school, you had to memorize that definition forwards and backwards. I knew that definition. I still know that definition. I know where the commas go. I know where to put the period. I knew how to do exclamation point. The first jury trial I had, I used that definition. I was so proud of myself because I had the comma where it went. I paused for dramatic effect. And after that jury trial, guess what? There is no longer a definition for proof beyond a reasonable doubt. So if you're ever in a contest and they ask you for the definition of it or what it used to be, you can use me as a phone a friend. But for now, there is no definition for it. So when I would do jury trials, I would tell people what it was not. For example, next door, the historic courthouse, the one with the green rooftop, they handle civil matters. They handle your car accidents, things of that nature. The burden of proof for that type of case is preponderance of the evidence. More likely than not, something happened. If you're ever on a jury in a criminal case and you are deliberating and you are saying to yourself, well, I think that happened more likely than not, you know that you are not at the burden of proof beyond a reasonable doubt, because that's the burden if you are on the civil side at the historic courtroom. The other burden they have is the burden they have called clear and convincing evidence. Clear and convincing evidence is also what's used in civil cases. Those are the cases when the state says that you are not a good parent, you are a danger to your child, and they want to terminate your parental rights and legally take away your right to parent your child. That is also on the civil side. Guess what? Proof beyond a reasonable doubt is a higher burden than clear and convincing evidence. Does everyone understand?
Yes.
Now, there are two phases to any trial. The first phase, people love to call it the innocence phase, but it's not. Phase one is simply, did the state prove their case or not? The first phase is either guilty or not guilty. It's not innocent, not innocent. That's phase one. If someone is found not guilty, there is not a phase two, because phase two is the punishment phase. So if you were to find someone guilty, then you go to the punishment phase. Our law says that when someone is going to trial in a criminal case, they must make an election or a selection for punishment. It's the law. They either have to decide if they were found guilty, they would go to the jury for punishment or go to the court for punishment. By making an election or selection, no one is saying, hey, I'm guilty. This is why I'm choosing this. It's just the law requires it, and you cannot hold it against someone because they have made an election or selection. Does everyone understand?
Yes.
Is there anyone who will hold it against Mr. Dotson for making an election or selection to punishment? All right. In this case, Mr. Dotson has decided that if he were found guilty, he would ask for the jury to do punishment. Is there anyone here who, for religious reasons, are not able to sit in judgment or pass punishment? If there is, please raise your card. All right. So number 22. And everyone, when I say sit in punishment, nobody likes to punish people, right? I mean that it's damaging to your psyche. I mean that for religious reasons, you just cannot sit in punishment. So I want to make sure that that's clear. All right. Now, the range of punishment in this type of case is anywhere from 2 to 10 years or 2 to 20 years in prison. That's the range of punishment. Now, people will say, oh my gosh, that's a wide range, right? Because it's anywhere from 2, 3, 4, all the way up to 20. And people always say, can I consider that? Can I not consider it? Can I give it? When you are asked a question about whether you can give a particular punishment or not, here's the difficulty in that. In regards to this case, you don't know anything about this case. You're not going to get any facts of this case. All the parties will be speaking hypothetically. Does everyone understand?
Yes.
Yes. Yes, you may. All right, ladies and gentlemen, this is one of these breaks that I'm going to give you all, just a short. I'll give you all a 15-minute break. And then we're going to finish up and we'll continue. So if anyone needs to take a restroom break, let me tell you where the restrooms are. If you find the stairs, you can go up or down. On either side of those stairs are going to be a restroom, all right? So I'm going to have you all come back here no later than 2:50, all right? And do not come inside the courtroom, just line up in the hallway. If you want to leave your personal items, you can leave your personal items. We will be in here, so nothing will happen to them, but please leave the expensive cards behind. All right, everyone, please rise for the jurors.
I would imagine so with this case, Your
Yeah.
Honor.
I mean,
All right, so y'all just calling one witness.
I would.
Okay.
No.
Okay. All righty. Oh, no, I always tease about that.
Are you doing?
Okay.
If that's okay.
Yeah, sure. Always just like to know, so I can put it out there.
Right.
So, Sean, they say that nobody has won the Powerball.
No one won the Powerball. However, someone won $3 million off of a $50 scratch off bought on my side of town.
Well, don't put my name out there.
It was just on the news today. I have an uncle that won.
Put in for jury trial, put him on impact.
He's like the luckiest person I've ever met. Every time there's like raffles, anything we're ever at, he wins.
Or do we have,
And
they're
he
coming
was
back on the
not
30th for
making
impact?
money.
Okay, so put it on the floor.
Just lose money.
And if you'll write that in the
It's not
file.
anyone in our family for like 10 years.
That'd be me. I'm greedy. December 4th.
Yes.
Perfect.
No, it's Soria.
Oh, okay.
And then they're doing the plea on his case. Dakari. Oh, I'm just giving you those files. Oh, sorry. This is Dakari. What file did I give you? That one? Mhm.
Yeah, and,
This one is supposed to be a plea. The attorney is supposed to be coming back, because they're coming back on the 5th, October 5th. And this one,
I always do too.
they're working on the plea
That's what I
paperwork.
heard the first time.
So Norma, if they're not able to take a break and do this today, we call this for tomorrow.
But I promise you.
Do you need to call or?
Thank you. I was-
do I do with, just parking?
Put it down for impact.
On December 4th, yeah, that was my motion.
Ready, Your Honor?
Yes.
Yes. Everybody knows their spot.
I think. Oh, please be seated. We stand for you.
No.
No, you're like, what? All right, everyone, please be seated. So where we left off, the range of punishment in these type of cases, it's anywhere from 2 to 10 or 2 to 20. That is a wide range of punishment. So in these type of cases, you can sentence someone to 2 years, 2, 3, 4, 5, 6, 7, 8, 10, all the way up to 20. Does everyone understand?
Yes.
Now, people will always want to ask you, in this case, what would you give? Would you be willing to give 2 years? Would you be willing to give 5 years or 20 years? And it's always difficult for jurors to say, because your first inclination is, yeah, but I need to know the facts before I know what I would give. Is that correct?
Yes.
So you want to know, tell me about the case, then I'll be able to tell you what I can give. But when I ask you about considering the full range of punishment, it's not whether you can give it, it's whether or not you can consider it. So there are many cases that you could probably think of where, hey, this is a case where I give somebody two years. Maybe they're 18. Maybe they did something crazy and foolish that maybe somebody who was 21 wouldn't do. And in that case, you may say, you know what? I would give that person 2 years. But then you may have somebody and you say, you know what? That person in that situation, maybe I give 10 years, maybe I give 15 years, maybe I would give 20 years. Does everyone understand? So can everybody think of a scenario in your head where maybe you would give somebody 2 years? Is there anybody who can't think of a scenario in your head where you would give somebody 2 years? All right. Is there anyone here who can't think of a scenario where maybe they would give somebody 20 years? Number 32. And what is your number 68? All right, thank you. All right, the next thing I want to talk to you about, I'm going to give you a hypothetical. Do not add any facts to my hypothetical. All right? So first question. Let's say that someone is in an alley. They're walking down an alley by themselves. Maybe they got lost and got turned around. And so they're the only person in the alley. And someone comes upon them and robs them. They take their items. The person calls the police and said, hey, I was just robbed. And person B is the one who took my items. Does everyone follow that scenario?
Yes.
Is there anyone here who thinks that, you know what, there were only 2 people in that alley? So one, we're not going to do anything with that case because it's a he said, she said, or he said, or she said. Is there anyone here who thinks that that person should not call the police and people should just say, oh, well, it's just you and whoever else was in the alley? Is there anyone who feels that way? All right. So here's the hypothetical I'm going to give you. A witness comes to court. They are sworn in to tell the truth. They sit in this seat. They testify. You listen to them testify. You believe what they are saying. There's no question that they saw what they saw. They were not wearing eyeglasses because maybe they have perfect vision. They don't have a problem with their memory. Is everyone following the hypothetical? And they say, person B, that's the person who robbed me. They robbed me on December 1st, 2019. I remember it that day because it was my birthday and this is who I saw and that's the person who did it. And it happened in Bexar County. Everybody's following the hypothetical? Is there anyone here who would say, you know what? I believe that person has proved all the elements of the state's case, but I still want more people. I'm not just going to go on that person's word, even though I believe what they testified to. Is there anyone who feels that way? All right, 4, 5, 6, 9, 14, 17. You can sit down. We can see you 30, 26, 32, 35, 41, 48, 52, 42, 43, 72, 65, and number 8. All right. The next question I want to ask, all of you have had a chance to see the parties who are involved in this case. Is there anyone here who recognize any of the parties who are involved in this case? Anyone from the state side, the defense side, or Mr. Dotson? If you recognize any of those parties, please raise your card. All right. Number 29 and 68. Number 29, who do you know?
Some of the district attorneys. I worked with the district attorney's office.
All right. Let me ask you this question. Even though you work with the district
I used to
attorney's
work with them,
office, pardon?
I used to work prior to them. Now I'm with the felony drug court with Judge Glenn.
Okay. So knowing that you used to work for the district attorney's office, if you were selected on this jury panel, would you be able to listen to any evidence that's presented and make your decision, if you can, on whether Mr. Dotson is guilty or not guilty based upon the evidence that you hear?
Absolutely, yes.
All right, thank you. Number 68, who do you know?
Gentleman on the right, I don't know his name.
Ah,
District Attorney,
oh, okay. And how do you know
from
him?
a case that I was involved in.
All right. And was this a case where you were a witness or something else?
Something else.
All right. All right. If you were selected to be on this jury panel, would you be able to make your decision on, if you can come to a decision on whether Mr. Dotson is guilty or not guilty based upon the evidence that you hear presented?
No, I don't think I could.
Well, I mean, here's the thing, everybody. We can't do, I don't think, maybe, because,
No, I would.
all right, thank you. All right, the next thing I want to talk about is languages. I love languages. I think they're beautiful. I had no idea I was going to be in San Antonio. I had no idea my career would take me here. I thought I would go from Louisiana and end up in France. So, of course, the language I chose to take was French. My friend said, Stpehanie, let's take Spanish together. And I was, no, I'm not going to be anywhere where I need Spanish. I'm going to, I'm going to retire at 21 and be in Paris. So, of course, that did not happen. So I am here. And when I went to undergrad school and graduate school and law school, there were always all of these students from different countries, which I'm like, America, catch up. Other countries, when they come here, they speak like 6 languages. One of my classmates spoke 6 languages. So I can pretty much say hurry up in every language because that was the only thing I was able to pick up that they were trying to teach me. So is there anyone here where English is not your first language? If it is, please raise your card. And when I call out your number, you can lower your card number 13, 34, 52, and 53. All right. Number 13, what is your first language?
Check.
Okay, that is so new. We have not had that before. How do you say hurry up? Okay, I'm gonna work on that. I like that. So have you been able to understand everything?
That's right. My 6th language.
Okay, your 6th language? Okay, what other languages do you speak? Now I'm curious.
Slovak, Polish, Russian, German, some English.
You say some English, but have you been able to understand everything that's been going on?
You were just asking if it's a second language.
Okay, all right. Thank you very much. Number 34.
Spanish. Oh, sorry.
That's okay. We're going to pretend like that never happened. All right. So Spanish, have you been able to understand everything?
Oh, yes. I mean, you asked, my first language is Spanish. I am fluent.
All right. Thank you. Number 52. And have you been able to understand everything? All right. Thank you. Number 53.
Spanish.
And have you been able to understand everything? All right. Thank you. Now, we expect that we're going to have jury selection today. And then on tomorrow, we're going to start with the actual jury trial. So I want to ask everybody, 1, is there anyone here who has some kind of travel arrangements that are scheduled, you can't put my name under your tickets. You are the only person who can use that, or has something coming up that's a time constraint for this trial. If that's the case, please raise your card, and once I call your number, you lower your card. And once I call the numbers, if I pass your number because you're shy about not raising your card, we will not call out your number. So I'm giving everybody a chance to raise their cards now. All right, we have 5, 6, 11, 13, 16, 25, 22, 23, 25, 26, 34, 35, 38, 43, 56, and 58. All right. Number 5, what's your time constraint?
It may not be. If, do we have off Saturday, Sunday, and Monday if it went that long?
We are not going to be here Saturday and Sunday unless you all say, hey, I really want to be here Saturday and Sunday.
Holiday,
I think things will probably be done this week.
then it won't be a problem.
Okay, all right. Thank you. Number 6.
I've had, over the last 5 weeks, I've had my father pass, and I had a dear friend who I was on POA for that I put in the hospice. So I've had to miss work, about 4.5 weeks of work, so I'm so far behind in my job. And I'm a supervisor for a IT brand at Randolph, and we have a software release coming up in the next couple of weeks, and so I'm just so far behind on everything. I'm just kind of befuddled, catching up on everything.
All right. Thank you so much for letting us know. And I'm sorry that has happened. Number 11.
Thursday, I have a doctor's appointment, and Friday I'm flying out of
All right. What time is the doctor's appointment?
15:15.
All right. So you're speaking military to us. What time is your doctor's appointment? I can do the math. All right. And on Friday, where are you headed?
Mississippi, Jackson, Mississippi.
What are you doing in Jackson, Mississippi?
Seeing my daughter who plays D1 volleyball her last year.
Okay. All right. Does she want you to come to the game? Sometimes it makes people more nervous. Number 13.
Out of state, Phoenix, Arizona.
What are you doing in Phoenix? Doing what? Okay. All right, number 16.
My meetings that I had scheduled today are for tomorrow, so I'm.
Meetings for work. All right, number 22.
I'm a single mother.
Mhm.
I have a single baby that comes in the house. So, I had cataract surgery for both eyes and the corneal replacement. And I work at home. So I get in the mornings where head mice and the tail mice, it blinds me.
Okay.
And I would have a hard time where I'm living at now to get here on time at 8 o'clock in the morning.
Oh, nobody's going to have to be here at 8. Okay.
And dropping my daughter off, I'm like, I don't have family here, so I'm the one that take her to school and pick her up.
Okay. All right. Thank you. Number 23.
Job interview, and I'd like to. But
Okay. We can't hear you.
I have a job interview at 2 p.m.
At 2 p.m. And that's tomorrow. All right, 25.
We had planned to take a trip to Minnesota to pick up a car for my sister-in-law who needs a car really bad, and then drop off our car, and take her car and drop it off in Michigan for her.
All right, and when is this happening?
We were planning on going tomorrow or Thursday.
Okay. All right, thank you. Oh, number 3 is late. We passed over 3. I'm just joking. What is your issue?
My wife is having spinal surgery on Thursday.
Okay,
So
all right. Thank you for letting us know. Thank you. Number 26.
Your Honor, I want to withdraw my objection to being, not objection, but stating why I couldn't, because you explained that this would be a shorter trial than I anticipated. Mine was not travel until the 27th this month.
Oh, where are you going on the 27th?
Italy.
Oh, wow. What parts? Oh, Florence is so beautiful. I love Florence. Oh, it's gorgeous. All right. I thought you just wanted to tell us to make us jealous or something. 34.
Your Honor, I just started a job yesterday and I have been on for 3 months and I just don't want to get any more. My new job.
All right, thank you. Number 35.
I have a medical procedure on Thursday.
All right, thank you. 38.
And then Sunday through Wednesday next week.
All right. So are you really taking a trip to New Orleans, but are you just saying that because I'm from Louisiana and you want me to be sympathetic? Okay. Oh, well, congratulations. So since you're going to the DMV at 8:30, I'm sure they'll have you out of there by 8:45. But we got to put that in the universe, because if you just think you're going to be there till midnight, then you're going to be there till midnight. All right, thank you for letting us know. Number 43.
Good afternoon. I'm a special education teacher for middle school and there is a substitute shortage, so it'd be really difficult to find coverage.
All right, thank you. 56.
I have a job interview scheduled on Tuesday and travel plans at the end of next week.
Okay. I don't think we're going to be here on this trial on Tuesday. We shall see. All right, thank you. Number 58.
Yes, ma'am. I got up to here with bills and I don't get paid if I'm out here. Every time I come to jury duty, I don't get paid for those days, only that whatever they give me now.
Okay. All right, thank you. All right, so each of you have had a chance to hear people speak up. So other than meeting each other downstairs and talking to each other in the hallway, do any of you know each other from somewhere other than those two places? All right, number 60. Oh, somebody else had better raise their hand. Number 39. Is there anyone else? All right, 60. How do you know number 39?
We work together.
Oh. So you all will be able to tell them, no, it's true, she was here. Okay. All right, anyone else? So before I turn it over to the state, I'm going to tell you all two stories and both of them are true. So the first one, I know that jury duty is a hassle. I always tell people jury duty is an inconvenience, and I'll explain to you why I say it's an inconvenience. Your country only asks two things of you. One, pay taxes, and two, report to jury duty. And I say it's an inconvenience because you have to come downtown for jury duty. There are so many one-ways that somebody who designed the city thinks that one-ways will make traffic go quicker, and it doesn't. It just gets everybody frustrated when you're coming downtown for the first time because you are saying, the building's right there. If I could turn right, and then we got construction, and then you have to pay for parking, and you're probably saying, I'm doing a service by coming down for jury duty. Why am I being made to pay for parking? I don't write the rules, so I'm not in charge of why you have to pay for parking. But I will tell you, it's an inconvenience. We cannot have jury trials unless we have jurors. There does no good to complain about the television about why did they do this or why did they do that if you're not a part of the process. My mother and my family grew up in this small town in Louisiana called Grand Cane, Louisiana. Population in its heyday, maybe 2,400 people, possibly. So all the teachers knew everybody. My uncle, extremely intelligent, and my mom would always say how intelligent he was. And the teachers knew them, and the teachers knew all their students. So with my uncle, he kept getting passed upper grade because he was so intelligent. I remember when computers were coming out, he knew everything there was to know about a computer, and people were always trying to hire him. So lo and behold, my uncle is going through school at rapid pace because he's super intelligent. Then his sisters and his brother come in behind him, and the teachers are saying, you all had better show us something because your brother is super intelligent and we're expecting this from you all too. So of course, that made it difficult on his siblings. So my uncle graduates from high school. The Vietnam War starts. My uncle goes to my grandmother and he says, there's nothing for me here in Grand Cane. The way the society is, I'm not going to be able to get to do things that I want to do. So I want to sign up and just go ahead and go to Vietnam because they're drafting all of the boys here anyway. So my grandmother had to sign for him, and she signed for him. So imagine that's her firstborn child. It's not like you have today where you have a computer and you can sit down at your computer and send emails to each other. It's not where you can pick up the phone and call, because during their time frame, when you wanted to make a phone call, you picked up the phone, the operator picked it up, and you gave them the 4 numbers that you wanted to connect to. It wasn't a situation where you have stations that are on TV 24 hours. They had 3 stations, NBC, ABC, and CBS. And NBC, it was pretty dicey on whether you were going to get that to work or not, because you have the rabbit ears, right? And then your programming would shut off, and then, they play the national anthem. I know some of the young people are like, what did you guys do when the TV went off? It just went off. Everybody goes to bed. So if you can imagine her sending her underage child off to Vietnam, nobody really knew where Vietnam was. And you're sending them off. You don't know when they're going to arrive because you're getting the snail mail. Then you got to figure out where you're supposed to write to deliver their mail. And then you don't know if they're going to come back home or not. You realize they've been sent to Vietnam, and you learn months later, 6 months. My grandmother would always say, it was 6 to 8 months before I knew, yes, he's in Vietnam. And then you're trying to send letters there. And you only got a letter from Vietnam because, the higher ups make you write a letter to your parent to say, I've arrived safely. That's all they know. And then you're waiting to get letters back, and it's months and months before you get letters. So you don't know if your child is all right or not. So that's a sacrifice. That's why I say jury duty is an inconvenience. And sometimes we forget the true definition of sacrifice and the true definition of inconvenience. Just so you know, my uncle made it back from Vietnam. He has since passed. We miss him dearly. But I always tell that story so people can realize that in the big scheme of things, this is all an inconvenience. The other thing I want to talk to you about is a friend I had in law school. I always wanted to practice criminal law. Always been my passion. My friend wanted to do civil. So if there are civil attorneys here, you know what I'm about to say is true. Civil attorneys are not in court as much as people who practice criminal law. Usually, if you practice criminal law, you're in court almost every day. You're in trial almost at least once a month. So my friend, we didn't get a chance to talk a lot because she's doing civil work. I'm doing criminal work. She calls me one day and she says, I have jury duty. Let's do lunch. And we're like, great. We have lunch. It was like no time had passed at all. And so we're having lunch, and I ask her, how's jury duty going? And she's like, it's fabulous. Now, since I'm a judge, I'm like, how can it be fabulous? Looking back on it, I wasn't the judge, so how is it even fabulous? Hey, not that much laughter on that. So she said, oh no, it's like when we were in law school. I'm on the back row and I'm keeping my head down and I'm not saying anything. And so I start laughing. She says, "What's so funny?" I said, "We're going to be able to have lunch every week. It's great." So I tell that story because both the state and the defense want to get a chance to know you. And they have this small window to get a chance to know you. And if they don't get to know you at all, then you'll probably end up on this jury panel. And of course, we want people on the panel who can be fair. And when both sides ask you whether or not you can be fair, here's the real question. Whether or not, if you are selected to sit on this jury, that whatever has happened in your life, because we all have things that have happened in our past, but the key is whether or not, if you're on the jury, you can listen to the evidence that's presented in this case. And if you can, make a decision based upon what comes from inside the courtroom on whether or not somebody's guilty or not guilty. Does everyone understand?
Yes.
All right, with that being said, I am going to turn it over to the state.
Thank you, Judge. Well, good afternoon, everyone. Again, my name is Zach Dunn, and this is my partner, Travis Banks. Just like Judge said, we have a few minutes to get to know you, ask you questions. There are no trick questions. These are all hypothetical. It's just trying to gauge what you feel about certain things. This pin is the Assistant District Attorney pin. So this means that on day one, Travis and I raised our hands and took an oath not to pursue convictions, but to pursue justice. And that's why we're here today. That's the only reason we're here today. And so, yep, today is serious, and the rest of the days this week will be serious. But in a brief, to add a brief moment of levity, I always like to start things off. You may be thinking in this regal courtroom that I'll mention some great films of days gone by, maybe The Verdict or A Few Good Men, Anatomy of a Murder. But I'm wondering, has anyone ever seen the B movie? The Jerry Seinfeld, the B movie? Any hands? All right, it's a mixed bag. Not the world's greatest movie, certainly didn't win any awards, but long story short, it's a movie about bees, but there's a side character, this mosquito. And all we know about the mosquito is his dream is to become an attorney, okay? So you see this mosquito in the beginning of the movie about bees. You don't see the mosquito at all until the very end of the movie. And the mosquito comes in with a suit and a briefcase, and all the bees are like, "Hey, what happened? Like, we know you wanted to be an attorney. You kind of look like one. What happened?" And he goes, "I was already a blood-sucking parasite. All I needed was a briefcase." Thank you. I'll be here all week. So again, just wanted to start things off with a moment of levity because, of course, you have a very serious responsibility here. And we always take our oath and why we're here to pursue justice very seriously. So again, just trying to get to know everybody. We'll talk to you for a little bit, and then defense. You've already heard, of course, from the judge. So what we're looking for is fair and impartial jurors, right? We understand that people have strong opinions on certain topics or things. You're allowed to have those opinions. You're more than welcome to have those opinions. But really, we're kind of getting you to consider maybe a range of punishment or certain potential hypothetical facts or certain areas of the law. And that's pretty basic, but so far, everyone following me? You guys are wonderful. Okay, very, very, very simple, but again, we're just kind of walking through things. Convictions are based on evidence. Potential convictions are based on potential evidence, right? It's my job to bring you that evidence. Anyone know what this movie is? Anyone can raise their yes, juror number 33.
Excuse
You
me.
can just yes, yes, that's my bad. Cheech and Chong, that's correct. So if there was let's say there's a hypothetical trial about the use of illegal substances, okay? Do we think that the two of them are going to be really fair and impartial jurors? No. Juror number 33, no. Everyone's pretty much nodding their head, agreeing, right? Let's say, for example, I go out to a lot of you parked in the garage, correct? Let's say you go out, or let's say you came in this morning, okay? You came in this morning and you look at a bird in the sky and someone smashes your window and runs away. And lo and behold, in the 187th, there's a property damage crime. There's a smashed window case, right? Even if it wasn't for your car, makes sense how you probably wouldn't be a fair and impartial juror, right? It just happened to you. Does that make sense? Right, I appreciate the head nods. Yep, absolutely. So we want fair and impartial jurors. Now, the law of this case, right, we're speaking in very general terms, not getting into the facts, where again, we're just talking about the cause itself. This is assault causing bodily injury to a family or dating partner as a second offense. Okay, that's why we're here today in broad terms. Now, there are really two broad categories of assault, but we're going to be focusing on an injury under Texas law. Now, an injury, assault requires really a mental state. Okay, so in the case of Zach against Travis, all of you are watching me walk over to him. If I go right now and I kind of yank his hair like that, seems like I maybe intentionally did that, correct? Right, that's a mental state. I had to walk over, grab his hair and yank it. That's intentional. Knowingly is that I'm nearly certain that the result of my conduct is going to result in a harm. Okay, if I'm standing 2 feet away from Travis and I've got a baseball in my hand and I throw it at Travis's face. Okay, yes, I get the intent aspect, but knowingly, I have a pretty good idea that from 2 feet away, that baseball was going to hit his face. That makes sense? Recklessly is another element that's, it has its own legal definition where it's basically a disregard of the conduct, but you take that action anyways. You may be like, Zach, you lost me. You're talking about intent, you're talking about knowing, you're talking about reckless. All this slide is meant to show you is that today, and as through the process of being jurors, there has to be the right mental state with respect to us meeting our elements. We have to show that someone either intentionally, knowingly, or recklessly took that action. Does that make sense to everybody? So any guesses? Let's start lucky number 7, juror number 7. What do you think may qualify as bodily injury? What's an example of maybe a bodily injury? A bruise. Fantastic. Juror number 7, I appreciate that. Juror number 17. What is, besides bruises, what else? Scarring. A scar. Sure. Juror number 24. A broken limb. A broken limb. All kinds of things, right? There's all kinds of variables for what could be an injury. And under Texas law, the threshold is actually much lower. All you have to do is feel pain, illness, or any impairment of physical condition. Okay, so not a single one of you are this man right here. None of you are Travis. Okay, right? Only Travis is Travis. If I come up and again, poor guy, I grab his hair and I yank it. Juror number 40. Where's juror number 40? Juror number 40. What do you think? I pulled Travis's hair. Do you think he felt physical pain, illness, or any impairment of physical condition?
Yes.
And why do you say that?
I can't hear you, ma'am. Can you please repeat?
Yes.
Because I physically pulled his hair, right? You can infer, you're not him, right? But you're inferring that if you watch me do it right now, he's going to feel pain, right? But, and thank you, juror number 40. I appreciate it. Juror number 41. If I, 41. Juror number 41, let's say if I pull his hair, right? Is that going to leave any, are you going to know, is there any way to know that that happened unless you saw it?
Likely not.
Most likely not, because there's not going to be a broken bone or a bruise. But again, you could still, it absolutely could. No, and I appreciate that. But for the most part, again, there's going to be no physical indication, but certainly that is an example of pain. You would agree?
Yeah.
Does anybody disagree with that? Everyone think, anyone have any thought? Thank you. I appreciate it. Does anyone disagree? Anyone have any thoughts that are like, you know, Zach, I hear you, but I don't agree. Everyone pretty much with me? Okay. Baby steps. Again, how much injury is enough? We went through pain. So we went through assault, again, kind of laying out what that is, pain, bodily injury. Another thing we'll have to prove to you is that it's a family violence matter, right? So there's all kinds of indications for family violence under the code. You could be dating, married, parents, siblings, things of that nature. The relationships are largely pretty simple and they make a lot of sense. But that's something that we will be discussing. Okay, does that make sense? Kind of why you're here? This isn't people that have never met, right? Our burden is to prove that there was some aspect of a family dynamic or relationship. Everyone follow? Awesome, you guys are great. Okay. This is going to be a two-part question, okay? And again, when I ask this question, all I ask of you is to just raise your placard. I'm not going to be getting super in-depth with the details, but again, I'm just going to have you raise your placard if this applies to you, okay? It's a two-parter. Part one. Anybody, any member, all the way, every single person in the room, okay? Have you yourself been a victim of domestic or family violence, or you know someone that has been a victim or of family or domestic violence? Okay. Again, as soon as I call your number, go ahead and feel free to put your placard down. Number 1, 2, 6, 7, 9, 10, 11, 12, 13, 14, 15, 16, 17, 20, 22, 23, 24, 25, 26, 27, 28, 30, 31, 32, 33, 34, 35, 36, 39, 40, 41, 42, 43, 46, 48, 52, 53, 54, 55, 56, 57, 59, 60, 61, 63, 65, 66, 67, 68, 69, 70, 71, 72, 73, and 75. Okay. Thank you all for participating in raising your placards. This is a follow-up question only for the people that just raised their placards. So for example, number 3, you did not raise your placard, right? This does not apply to you. But number 2, you did. This applies to you, okay? Of every single person that just raised your placard, given your experience, either as a victim of family or domestic violence, or knowing someone that's been a victim of family or domestic violence, given that experience, how many of you are unequivocally certain that you could not, capital N-O-T, you could not be a fair and impartial juror in this case? That is. Okay, again, please, does everybody understand what I'm asking? Yeah.
If you could just pause it 1 second.
Yes, Your Honor.
This is what he's asking. By fair and impartial, everybody has their issues. Everybody has things that may have happened to them in their past. What he's asking is whether or not, in this case, if you were selected to sit on this jury, would you be able to base a decision, if you can come to a decision, base it upon what you hear from the evidence that's presented to you, or will you not be able to do that? So, of those people who have raised their cards, who is, if there's anyone who is unable, if you were selected on the jury, to listen to the evidence in this case, whatever that evidence may be, if you're able to come to a decision, is there anyone here who would not be able to strictly base whatever their decision there is on what you hear in this case? Raise your card if you would not be able to do that. There you go.
Thank you.
You're
I
welcome.
appreciate it. So again, everyone, just like the judge said, again, I'm going to call your placard number, and then as soon as I call it, please feel free to put it down. Number 6. I apologize. Are you number 9? You were number 9. Number 6, 7, 13, 15, 17, 20, 22, 23, 26, 27, 28, 30, 32, 33, 34, 46, 48, 52, 54, 63, 68, number 69. Okay, thank you all for your participation. We'll be delving into that at a future time, more than likely. So the law of this case is really quite simple. We've gone over the family dynamic, we've gone over assault and kind of what that entails under the Texas code. For this case, basically the assault bodily injury is what we talked about. We're also gonna have to prove to you a proof of a second previous in time offense. We're not gonna get into the details of any of that, but that's why you're in a felony court, right? That's why you're in the 187. There's something in the realm of a second offense that we are gonna have to prove to you took place. And because of that, on top of the assault, that's how it ended up in felony court. Juror number 27. That make sense? Juror number 27. What do you think? Does that make sense?
Yes.
Okay, I appreciate it. Juror number 44. Am I making sense?
Yes.
Okay, I appreciate you guys. You're my litmus test. Everyone else pretty much know where I'm coming from? Okay, thank you guys. Okay, I would like to briefly touch on beyond a reasonable doubt. Let's go back to the judge's hypothetical about being in an alley, right? As one of my semi-bosses says, crimes don't occur on the 50-yard line at a Dallas Cowboys game, right? And the point of that is the standard is beyond a reasonable doubt because really kind of the unspoken burden that exists is being there, right? In the case of me, so the alley example that judge gave, let's say Travis is up and I are in an aisle. Let's say this right here is an aisle and I come up and I pull his hair. 75 people just watched it happen, right? Juror number 13. If you are sitting right there, if you watch me pull Travis's hair right now, how certain are you that took place? 100% because you saw it. But the standard is beyond a reasonable doubt because, again, for the most part, crimes are not happening with 75 of your closest friends watching. Okay, so it's not 100%. It is the highest burden in the criminal justice system, in the American system of laws and courts. It's the highest, but it is not 100% because, again, just like you stated, unless you're watching the crime of me pulling his hair, you weren't there. Does that make sense to everybody? Everybody's pretty comfortable with that standard, the highest in the system. There is no doubt about it, but it is not 100% because not a one of you was there that day. Does that make sense? Okay, you guys are wonderful. Thank you for the continual feedback. It very much helps. What is this? Probably a gun. My great puzzle examples. Puzzling, how that always comes up. Sorry, that was low hanging fruit. I had to. Okay, this is, again, we're going through things baby steps wise, but of course, a verdict either way is always based on the evidence, okay? Evidence comes from the witness stand. So our job is to put on witnesses. Those witnesses will either verbally say stuff and speak things under oath, right? That's testimony. Testimony is evidence. You're the judge of their credibility. Or we can bring in things through them, different types of evidence, maybe a photo. Maybe if an officer took a photo, we would want them there. Or if they were the reporting officer and they were there that night, we could bring in certain things through them, okay? Your job, though, regardless of that witness's profession or uniform or personal experience, your job is to essentially give everybody a fair shot to be credible or not credible, not make any predetermined judgments based on, again, if they're wearing a uniform, and able to hear every single person on the stand, judge their credibility based off of what you can see on the stand. Does that make sense? Okay, juror number 38, where are you at? Juror number 38. Let's say someone comes on the stand and they're wearing a uniform. Let's say they're an officer of any range, type, or sort. Given what I just stated, right? the goal is that you would be able to judge their credibility like anybody else's. They don't get more or less credibility based on the fact that they're wearing a uniform. How do you feel about that? You feel okay with that? Yeah, that totally makes sense. No, nothing crazy going on. Thank you. Sorry to call you out, but thank you. I appreciate it. Who disagrees with juror number 38? Who would say, you know what? Maybe, and I'll just stick, it's an easy example. That's why it's up there. Let's say it's an officer, they're wearing a uniform. How many people in the audience would either give that person kind of more credibility because they're wearing a uniform, or less credibility because they're wearing a uniform? Does that, my question makes sense? Okay, yeah, we got some feedback here. Okay. Let's go, we're gonna bifurcate. We're gonna split this question into two parts, okay? Let's just stick on the topic of a uniform. How many of you would give an individual wearing a uniform more credibility just off the bat than the average person? Because they're wearing a uniform. Okay, please raise your placards. Okay. Okay, all right. That's going to be juror number 11, 17, 25, 27, 28, 32, 34, 44, 47. Okay, thank you all for your participation. Now in the reverse. How many of you will see potentially an officer take the stand or someone in uniform, and automatically, just based on the uniform and not anything they say on the stand, you're thinking, you know what? I'm going to trust you a little bit less than I would otherwise. How many of you that would apply to? Okay. Juror number 23, 33, 42, 68, and 72. Okay, we appreciate your feedback. Judge already spoke on what we like to call the one witness rule. Again, it's not codified. There is like, you don't open up a code book and it goes the one witness rule, but a series of legal principles and how the justice system works. Again, just a judge's example, there's only one person there hypothetically, and that person meets every element. You believe them. So in other words, under the judge's example, and again, under the legal principle of this one witness rule, the state, Travis and myself, call someone, they sit right there and they take the stand. They speak under oath and you believe them beyond a reasonable doubt. Every single element that we're supposed to meet, right? Beyond a reasonable doubt. They take the stand and you believe them beyond a reasonable doubt, okay? The question is, would anyone hold the state to a higher burden? And I know we went into that, but I just want to clarify from just the state's perspective and really kind of add a great addition to what the judge laid out. Does anybody have any reservations with that principle or concept? Again, I know this is asked before, but it's important to kind of delve into it. So we're going to go ahead and keep your placards up. Thank you. Juror number 13, I appreciate it. Juror number 26, 28, 30, 38, 48, 69, and 72. When it comes to punishments, so again, just like Judge stated, think of the criminal justice system here in Texas as being really two things. You have we call it the guilt innocence, right? So whatever the result of that is, a guilty or an innocent. Let's say hypothetically, it's a guilty, right? We meet our elements beyond a reasonable doubt. 12 jurors say guilty. We travel then over here to the universe of punishment, okay? And the important thing really is that you as jurors would be able to consider, right? That's an important word. You would need to be able to consider in the appropriate case, the full range of punishment, okay? Now, does anybody, we've already kind of gone into this. Does anybody have any additional thoughts or questions or reservations based on what the judge had spoken about previously and kind of what I'm talking about now with respect to the hypothetical second aspect of every trial, which is the punishment phase. Any questions? Not, that's very okay. Okay. Just one moment. Just one more moment of the court's time, Your
Yes.
Honor. Thank you all very much for your time and participation. And that's it from the state. Thank you all.
All right. Does anyone need a break before I turn it over to the defense?
No.
All right, defense.
Yes.
Defense, you may proceed.
Hi, how is everyone? So my name is Elizabeth Russell and I represent Todd Dotson. So the first thing, well, why should they're not working?
So, oh, you know what it is. I got you.
It'll be very rough if we're not using the clicker.
No, I got it. Yep, absolutely right.
Okay, so I want you to be 100% honest with me. Because we can handle the truth. So is everyone saying that movie, You Can't Handle the Truth? Yeah, everyone knows what we're talking about. So we really just need you to be honest in here. There's no wrong answers. It doesn't make you a bad citizen of Bear County. It doesn't make you a bad person. We just want people that are going to be honest and fair to both the state and to Todd. Okay. So who's on trial today? Wrong. The state and their case. Let's talk a little about that. Todd doesn't have to prove anything, right? Nothing. Who has to prove something? These two guys right here, right? And what do they have to prove? Number 4, 5. What does it say have to
Beyond
prove?
a reasonable.
They have to prove it beyond a reasonable doubt, but what are they proving to you?
That he's guilty.
Okay, and they're proving that through certain elements, right?
Right.
And they talked a little bit about those earlier, right?
Yes.
And you're gonna weigh each one of those.
Yeah.
Go ahead.
Oh, sorry.
Excuse me. I'll slow down.
Slow down and one at a time, please. Sorry. Assault, like I have the intention or knowingly done.
That's way better than I was asking.
Oh, okay.
Just the elements, right? They need to prove the elements to you, the elements that make up their case, right?
Yeah.
And so you're gonna judge each one of those elements, and each piece of evidence they present to you beyond a reasonable doubt. So it's not a overall summary of what's going on. And you think overall, they pretty much proved it beyond a reasonable doubt. No, it's each and everything you're gonna look at individually and make sure that you're holding them to that burden. Does everyone understand that?
Yes.
You don't nod your head, I'm gonna call your number, I promise you. All right. So domestic violence in Bexar County. Who here believes that Bexar County has a worse problem than other areas of the country with domestic violence? Number 12, number 6, 7. Let's start over. Number 1, 6, 7, 12, 13, 15, 22, 25 through 27, 32, 36, 38, 48, 60, 61, 65, and 68. Now, of those people that say that Bexar County has more of a problem with domestic violence than anywhere else in the country, why do you believe that? So I can start over here with you. Why do you feel that way?
It's statistically proven that it's.
Statistically proven. And where are you getting those statistics from? The news?
Yes.
The news, okay. And based on those statistics, do you feel like you could still be fair in a case like this when you're reading statistics like that? You can still be fair. Anyone that just raised their placard?
I didn't catch her answer.
She said yes. Anyone that just raised their placard and said that it's worse here in Bexar County than anywhere else, all those people think that they could still be fair to Todd, even based on those statistics. Anyone that doesn't feel like they can't be fair? Yeah. Oh, I'm sorry. Number 27. We can't be fair. 6 can't be fair. 27, you can't be fair. 68 and 48. So I'm not here to say that I like family violence. I'm not here to say that I don't think there's a problem with family violence in Bexar County. My job is to hold the state to their obligation, right, and their burden, and to make sure Todd is fairly represented. Does everyone understand that?
Yes.
And while we're talking about that, if you were arrested with a crime, number 68, if you were arrested with a crime, what type of attorney would you want?
A federal attorney.
A federal attorney. What if it's just here in state court, you're arrested with a crime? What type of personality would you want in your attorney?
I guess a tough attorney, aggressive attorney.
A fighter, right?
Right.
And so if you see me be aggressive in this case, are you going to hold it against Todd?
No.
Because you're going to understand that I'm here to fight for Todd, right? So can I get permission from all of you to be aggressive for Todd?
Yes.
I'm so sorry. I wasn't expecting the light overhead. Very hard to read. So Zach talked to you a little bit about intentionally, knowingly, or recklessly. So let's talk a little bit more about that. So when they're proving an assaultive offense, they have to prove the mens rea, that he understood what he is doing, right? And part of that is either proving that he intentionally was doing it, he knowingly knew, he intentionally meant to cause the result, he knowingly knew that the result was going to occur, or he acted recklessly and that result occurred. So let's talk a little bit about recklessly. Number 8. You're number 8, right? Okay, so if you accidentally bump into someone and they get hurt, do you feel like you are recklessly caused them to get hurt? And why not?
Because it wasn't intentional and I was not negligent in my movement.
And so would you have had any idea that they were going to get hurt by accidentally bumping into them?
No.
And so what would you expect? What type of evidence would you expect if it was a reckless mens rea? If they were trying to prove that it was a reckless action, what are you wanting to hear from the witnesses?
I would want to hear that somebody was either not aware of their surroundings or if they were I guess to me reckless without taking into consideration all of the other aspects.
Okay, fair enough. And so what about if someone is just acting in their normal course of behavior of their day? Would you expect that to be the enough evidence for reckless?
In that case, I would want to know how that person is acting prior.
Okay, fair enough. Now, we're gonna go through three main areas today. The first is the presumption of innocence. You know, as Todd sits here, as Judge told you, Zach touched on a little bit also, Todd's innocent, right? The state hasn't proven anything yet, correct?
Yes.
So who walked in today and saw Todd and said he must have done something? Come on, guys, y'all promised me you're gonna be fair. You're saying you just think they randomly picked Todd? Number 34? Now, number 34, tell me why you thought Todd must have done something.
I know the setting of the court. And I saw the attorneys.
All right, so y'all, you're not making the court reporter's job easy. So if you're not on those rows, if you can stand and everyone keep your voice up so she can hear.
Yes, I said that I know the setting of the court and I saw I saw him and he didn't fit, you know, so I thought that he was, yes.
Okay, so he's in a suit jacket, right? I'm in a suit jacket.
Yes.
So why did you decide that Todd must have done something?
Yeah, just me, like I said, I mean, I know the setting of the court and I saw him on the side, so I assumed that he was being.
The one charge. But we're not just talking about the one charge. We're saying that you assumed that he had done something wrong.
Yes.
Okay, and so once the judge instructed you that you're not allowed to assume that, was that enough for you to say, okay, that's fine, I'll make the state start at the bottom and prove their case? That was enough for you?
No, I mean, like, maybe I misunderstood the question, and I thought that once I came in, I assumed that he was being, you know, well, he was the assistant or whatever, you know?
Okay. Does anyone else assume that he had done something wrong that raised their placard, number 60? So why did you assume that he had done something wrong?
Why else would you be in court?
Why else would you be in court, right? But the judge has instructed you now, right, that he has a presumption of innocence. And so do you understand now that maybe it wasn't wrong, but you weren't knowledgeable yet and you shouldn't have made those assumptions? Okay. So the next thing we're gonna talk about is the burden on the state. We're gonna go back to that in just a second. And finally, we're gonna talk a lot about beyond reasonable doubt. So let's talk about credibility. Most people call these type of cases he said, she said cases, right? Because there's two individuals. Sometimes he said, sometimes she said. But there's really only two individuals there. When you're determining who is telling the truth, how do you judge credibility? We'll start with number 4. How do you determine credibility?
Based on their senses, did they directly see it, hear it, whatever was going on? So it wasn't in a room next to them, and that's the one witness, they were physically in the room.
Okay, and so once they're sitting up on the witness stand and they're telling a story about what happened, their version of events, how do you determine if that person is telling the truth?
I think that's tricky. I mean, I think it depends on a lot of factors, right? Like you can look at body language, you can look at whether they hold eye contact, you can look at whether they pull back as they talk. There's a lot of things.
Okay, and those are all good. That's exactly what we're looking for. So who has any others that they use to determine credibility? 14.
What they stand to gain.
What they stand to gain? Absolutely. Anybody else? Credibility? Number 26.
If a witness sticks to his or her story, no matter how much the attorney can.
So consistency.
This is correct.
Okay. What if there are two different lay witnesses, two different just average people that are telling contradicting stories from the witness stand? How are you determining which one is telling the truth? Number 17.
The amount of evidence.
Okay, I know the court reporter cannot hear.
I'll ask him to repeat that.
The evidence that is able to be seen and shown is the most important.
So that is the evidence, you understand that the evidence still comes from testimony, right?
It does,
Okay.
but there's multiple things. You can have photos, videos, you can have families, friends of interactions they've had with the member before. There's multiple things that lead up to an event that occurred. Things that happen after the event that give you the context, clues you need to be successful in understanding what happened.
Okay, so is what you're saying is that you're looking at whether the evidence is matching what their testimony is on the witness stand? Anyone else have any other ways that they use to determine credibility? Number 48.
Family, background, history, sometimes socioeconomic factors. Because if you're in a much poorer area, sometimes those that the stress levels are high, so it's easy to take out the like aggressions and feelings up on someone else.
And so how does that play in for you? How does that play into credibility?
I know that I would probably have to hear the like facts of like whether it's that the person is a past drug user, whether it's if there's a history of family violence, whether it's if they were as a kid being a like abused, and then there's a cycle of pattern of the behaviors of family history, whether they come from a certain background and stuff.
And so you use that, the information you collect to determine whether or not they're being truthful from the witness stand.
Yeah, sometimes those certain things happen and all that. Like it's a matter of looking at their body movements, how they can like gut themselves. Sometimes patterns of speech, certain ticks that they might have. There's certain tells that certain people have when they tell the truth or like hide something.
Let's talk a little more about that. So body language, right? What are some body language tells that people have when they're not telling the truth?
It's the eyes, whether if the eyes are because of like when like someone's thinking of something, knows that the eyes move a certain way, and then if someone's lying, then the eyes move a certain way, or else those that they might like swarm in their sleep, kind of scratch their heads, kind of lose the gaze of the person though, and so like it's a childhood thing of like as a kid when you got in trouble you would try to hide and shirk from what was going on.
Fair enough. And so who here likes to be called on by their number and forced to stand up and talk? No one, right? The number one fear in the US is public speaking. Is there anyone in here that would disagree with that? They said, no, love to be called on. I'm pretty sure you're a judge, right? That's correct. You're a judge for the Western District?
United States Immigration.
And so you like to be called on, right?
That's my profession.
And you've been called on probably since law school.
True.
And you enjoyed standing up and giving your response if you knew the answer.
I'd like to be honest to the questions that are posed to me by counsel.
Fair enough. And so one person out of 75 of y'all, 2 people out of 75 of y'all had no issue, right? Standing up and saying, I have no fear of public speaking. But so some of those indicators that number
48.
Number 48 told us about that could mean that someone was lying. Those could also just mean that someone's nervous, right? Not necessarily nervous because they're lying, but just in general nervous. Does anyone disagree with that? Okay. Okay, so Zach talked a little bit about the burden of proof, right? He put a gun up, and it wasn't this exact gun, because when they used to put this gun up, sorry, we would come back with this gun. And so, but we have a bunch of people from the military in here. Tell me the difference between this gun or what's probably this gun and that one. 48.
With a different colored over at the end of the muzzle, that's a fake gun, whether if it's a squirt gun, pellet gun, whatever. It isn't the real firearm that's regularly black at the end.
So with this gun, you probably don't have all the evidence, right? Right. You probably couldn't be able to determine beyond a reasonable doubt with this gun, right? But this gun, you can pretty much see all the gun. And so does anyone disagree with the burden of proof, making sure that you have almost the whole picture together? Is there anyone in here that is unwilling or unable to serve as a juror? Number 13, number 6, number 20, number 23, number 26, number 27, number 28. I think I said 23 already. If I didn't, 23, 30, 32, 34, 35, 48, 54, 58, 63, 67, or 68. Is there any reason why anyone would not be a fair or impartial juror in this case for a reason other than domestic violence? Because all we've really talked about is domestic violence so far. So a reason other than domestic violence. 68. Were you raising your placard, sir?
It's not other than the domestic.
It's the same reason.
It is for domestic violence.
Thank you. No, 67. Number 30. Okay, let's talk about Amber and Johnny. Who watched this case? Number 14, you raise it loud and proud. So tell me about the Johnny Depp and Amber Heard case.
Oh, I watched the Netflix special too. Like I was in it. Like I became a lawyer.
So tell me what happened in the case.
Okay, so basically they did it in the UK first, then they ruled in favor of Amber Heard and Johnny Depp had to pay and all that stuff, and then Johnny Depp brought it back to the US and basically tried her for defamation and won. There was a lot of stuff, poop on the bed, finger cut off. It was amazing.
And so what was Amber Heard's allegation?
Hers against him, domestic violence.
Domestic violence. And was there actually evidence that came out that Amber Heard had committed domestic violence against Johnny Depp?
So wasn't it, that was, I feel like yes, but no, yes.
Number 6?
Yeah.
Yes,
Yeah.
right?
Yeah.
There was evidence. And it was after a full trial, right?
Right.
And after Amber testified, correct?
They kind of caught her.
They caught her. And so what do you mean by that?
Well, I mean, she was saying something, but they kept going back. And she didn't admit that she hit him, but
Oh, no, yeah.
that they were, her lawyer for Johnny Depp was like going, kind of, I don't want to say badgering, but he's kind of going back and saying, but you said this before, and you said this, but it proved that she wasn't telling the truth, and for the same story in several.
And so who here believes when there is an altercation between a man and a woman, no matter the circumstances, that the man is always at fault?
Repeat the question again, please.
If there's an altercation between a man and a woman, the man is, no matter the circumstances, the man is always at fault. Anyone? Has anyone in here ever belonged to, contributed to, or held a position with an organization involving domestic violence? Number 4, what organization?
I'm a Krav Maga instructor.
Krav Maga.
And I teach domestic violence victims.
Domestic violence victims, both men and women.
I've only worked with women in a capacity where I know that they're victims, but I do teach men and women in classes.
Thank you. Number 5.
I'm a registered nurse and we get patients and sometimes domestic violence.
I'm sorry, number 4, and I'll come back to you, number 5. Because of your work with Krav Maga and victims of domestic violence, would you have a bias in the case towards a domestic violence?
No.
Okay, and you'd be fair to Todd?
Absolutely.
Okay, number 5, would you still be fair to Todd? And I'm gonna ask a lot of questions, so just be careful not to answer until after I'm done speaking, but thank you. Number 6, what organization?
I was. I don't care.
Did you hear that? And because of your volunteer with the battered women's shelter, would you still be able to be fair to Todd? You don't think so? Okay, thank you for your honesty. Number 12? With CASA, are you an advocate for CASA?
Volunteer.
And because of your work with CASA, would you still be able to be fair to Todd in this type of case? You don't think so? Number 24.
I don't know if this counts, but I was a foster parent for children that came out of domestic abuse and drug abuse homes, so.
And so because of your experience as a foster parent, do you think you'd still be able to be fair to Todd in a case like
I
that?
can still be fair to that.
Okay, thank you, sir. Number 26.
I was a registered nurse, a nurse that threw in critical care in the military and the civilian, ran into a lot of victims.
And because of your experience with those victims, would you still be able to be fair to Todd? No. Number 27.
I contribute to the Battle Shelter. I know I cannot.
Thank you. Number 28.
I'm a school psychologist and worked with several children in the foster care system who've been domestically abused. I've also worked for a homeless shelter with clients who have been abused, really domestic abuse.
And because of that experience in your work, would you still be able to be fair to Todd?
Unfortunately, no.
No, thank you. Number 28, appreciate that. Number 30.
I do a campaign every year and I was. All of the letters, all of the big prices, all of the children.
And so because of your participation and your contributions, do you think you could still be fair to Todd in a case like this?
Truthfully, it's more because I'm more worried about catching COVID here than anything else. I'm very
Okay, fair enough. Number 34.
I was the victim police coordinator and I worked with better abuse. And also my sister was a victim of domestic violence.
I'm very sorry. Thank you for sharing that with us. Because of that, no, you would not be fair. 43.
So as a teacher, I have a legal and moral obligation to report abuse for children to ensure that that matter is investigated. As far as being fair, I've seen the impact that it has not only on our students, but family as a whole. And it would be difficult, I think, if I'm being honest.
And so we really need like a yes or no answer on a question like this. So yes, it would be difficult to be fair and you could not be fair to Todd.
I guess it depends on the case. I'd be fair in listening to the case, but to say that I could just turn off what my personal experience has been would be an unfair question to answer at this time. If I had to say yes or no to turning off my emotions and experience, that would be a no.
So I'm not asking you to turn off your emotions and experience. I'm asking if based on your prior experience as a mandatory reporter,
3
would
minutes.
you, I'm sorry, Judge?
3 minutes.
Would you still be able to be fair to Todd?
I would be fair in listening to the case.
Okay. Anyone else? Number 65.
Yes, I'm a social worker for University Hospital, so I worked with several women, getting them to the shelter.
And so because of your work, would you still be able to be fair to Todd?
Yes.
Yes, you would. Okay. And everyone understands that Todd has a right to remain silent, that no one is going to required to hear from Todd in order to make sure that the state is still held to their burden. Who absolutely needs to hear both sides of the story? Number 26, number 30, number 60, okay. Raise them all up, guys. Number 1, number 7, number 9, number 17, number 20, number 25, 26, 28, 30, 32, 42, 43, 48, 52, 53, 60, 63, 67, 70, 69, 74, and 75.
All right, you have 2 minutes remaining.
And so the last thing I want to talk about is the burden of proof. And so when we talk about burdens of proof, they start at the very, very end, right? The lowest threshold. And it's when you are innocent of a crime, right? No one has to prove anything when you're innocent of a crime. You start at the bottom and someone has to prove it against you, right? So the next thing we talk about, is highly unlikely. So when someone's highly unlikely, it means that you there's not barely any evidence, so not enough to really talk about. The next one is reasonable suspicion. That's what it requires for an officer to pull you over for a traffic violation. So they have to think that you probably committed a crime. The next one is a probable cause. And probable cause is what it is required to get a warrant to arrest you, a warrant to search your home. The officer has to be able to articulate the reason, what you violated, what type of offense you violated. Okay. The next one we talk about is the civil presumption. And it's more likely than not, right? So that means you just barely have enough evidence to tip the scales in the direction. So a lot of times these are like car accident cases, personal injury. That's what we're talking about there.
All right, that's 2 minutes. All right, ladies and gentlemen, what's going to end up happening is I'm going to have you step outside. And I'm going to bring you back in at 4:40. And at that time, you'll know if you're going to be on the panel or not. I gave you 30 minutes. I gave you an extra 2 minutes. So I didn't give them, you actually had more time than they had. Yes. Oh, we'll get on the record after they step up. So everyone, please
I agree with all those.
Yeah.
Oh, could you have dialect out?
You can even hear.
Okay.
Made my list since I was just.